Before I rest my quill by penning the disposition and final orders, I must thank the learned counsel for the parties in this matter for their industry, adherence to strict and short timelines, and the professional courtesy they extended each other. The breadth of their written submissions and the manner in which they ably highlighted those submissions orally made this court's task of judgment writing a lot easier. I would also like to thank the parties for maintaining decorum while attending court sessions, despite this being a highly emotive and charged matter. Disposition and final orders. Consequently, and for the following reasons, this court finds and determines that A. The amended petition dated 23rd December 2024, which is the subject of the proceedings herein, is found to be without merit and is dismissed accordingly. B. The Gazette Notice number 10351, volume CXXV1, number 130, dated 20th August, published on 21st August 2024, and issued by the respondent communicating the decision and or resolution of the Senate to remove the petitioner from office as the governor of Meru County by way of impeachment is affirmed for the purposes of these proceedings. C. Consequent to A and B above, the subsequent constitutional and statutory actions are free to take place as per the applicable timelines. And D. Each party shall bear their own costs. Dated, signed, and delivered in open court on this 14th day of March 2025. I did, before Councillor Mutuma, before you speak, I did state at the beginning that I would give you hard copies. As I was reading through, I saw one or two spelling mistakes, little double words. I will work on those. It will be uploaded into CTS. You'll have it today. So I'll do that. You'll have it on CTS today. I have signed the hard copy as required by the law with my handwritten corrections of those spelling mistakes. Yes, Councillor Mutuma?
Yes, thank you, Your Lordship, for the judgment. We note the expeditious nature in which the court has been able to dispose of this matter.
Yes.
My instructions, Your Lordship, is that we note from your judgment that a majority of the issues raised in the petition remain unresolved.
Yes.
And have been shelved and reserved for determination by the petition pending in Meru.
Yes.
We are therefore of a strong position that there is need to grant the petitioner an opportunity to have those issues which are the majority heard and determined.
Yes.
And since the court has had the opportunity to hear the issues being canvassed by all parties extensively,
yes,
it will then appreciate the need for the issues, for the very weighty issues to be determined.
Yes.
As such, Your Lordship, my instructions are to humbly request you to grant us temporary relief in whatever nature, but specifically an order of status quo to be maintained in the prevailing period, to allow the petitioner ably prosecute the issues pending before the Meru Court.
Yes.
And secondly, to also consider exercising a right of appeal in the Court of Appeal.
Yes.
This order of status quo, Your Lordship, can be structured in such a manner that it will be time-bound with the effect of automatically lapsing should the petitioner not have gotten a relief either from the Meru Court or from the Court of Appeal. We submit, Your Lordship, that there will be absolutely no prejudice on any of the parties if orders of status quo are maintained. In any case, it is the situation that has been prevailing since August 2024. Having that situation maintained for the next few weeks or months will not in any way prejudice the petitioners.
Just a moment, please repeat the period.
The period, my submission to Your Lordship is that in any case, the status quo has been prevailing since August 2024. There will be no prejudice if that same situation is maintained in the next few weeks, or rather for the next few weeks or months, just to ensure that the very weighty issues that the court has appreciated will have an opportunity to be determined on merit. The contrary is true, Your Lordship, that should an order of status quo not be issued, then effectively, whatever is pending in Meru, whatever is pending in the Court of Appeal, like the court has been noted, is all rendered an academic exercise. By dint of Article 23, we humbly request the court to issue conservatory orders court judgment. And to expedite our next move, Your Lordship, we humbly then request the court to direct the Deputy Registrar to supply us with type proceedings in this matter. And a copy of a certified judgment. That is all, Your Lordship.
Yes, thank you, my Lord. My Lord, we oppose the application for the first reason that this court has identified.
You oppose?
Yes, we oppose the application. My Lord, in your judgment, this court has identified that the petitioner's action of approaching two different courts was for this purpose exactly. This application is meant to dismiss the respondents from enjoying the fruits of their judgments after this court has started and had parties on merit. I know it is not true that there will be no prejudice. The court has found that on merit, the Senate did conduct a proper process within the law.
Yes.
And further suspending that process is not in the interest of justice. It is not in the interest of Article 10. And it is not what is envisaged under Article 181.
Yes.
My Lord, the petitioners having been found to be worthy of leaving office pursuant to Article 181, she has remedies in other courts, but at this point, this court is found insufficient. My Lord, the Meru Court is seized of the matters pending before it, and you have rightly declined to deal with those matters. That court can make appropriate orders concerning this issue. That court can quash any process. They have the power to do that based on the material before them, which is not before you this afternoon. My Lord, in the Wajir impeachment case, the court quashed the impeachment and the process proceeded after that. But for this court to be asked down is to take action based on the matters before the court in Meru is not proper, and it is negating the judgment delivered this morning and further suspending a proper decision of the Senate. My Lord, we oppose. Thank you.
Just a moment. So we have quite a number of interested parties. So I will call on one from each side. First interested party, Councillor.
Thank you, Malone.
Yes.
We should thank you for the industry that the court has shown in determining this dispute within the timelines that it has slowed down. Malone, we wish to submit to associate ourselves with the application by the petition. With regards to the request for a status quo order, this will enable the parties to ventilate the issues that the court has so far in the petition that filed in May.
Yes.
These interim orders will be able to avoid the disruption of the governance. We also wish to request for time copy of the proceedings as well as certified copies of the time. That is all I'm saying.
Councillor Kirimi.
Thank you, my Lord. On behalf of the interested parties who opposed the petition, my Lord, first and foremost, to thank you for the good judgment that you've delivered. And my Lord, on behalf of all my colleagues who appeared before you, and as the senior most counsel perhaps who appeared before you, we are sincerely grateful for the opportunity to canvass the issues we did before you. My Lord, so that I won't come again before you.
Yes.
We are also sincerely grateful to yourself for the professional courtesy that you extended to us.
Yes.
My Lord, in a specific way, we are very grateful that you found in your heart to forgive us when we did not appear to be proper before you.
Yes.
And we thank you specifically for pushing yourself and ourselves to meet the strict timelines that you set to canvass this petition before you. My Lord, turning to the application by Mr. Mutuma, we do oppose the same.
Yes.
First, you are now franked as official. Secondly, my Lord, the weighty issues Mr. Mutuma is raising from the bar cannot be raised in an oral application. We would kindly suggest that the petitioner finds it proper to file a formal application before you for urgent consideration and for a formal opportunity to all parties opposed here to file a response. Thirdly, Your Lordship, by making any decision that will amount to a stay of the negative orders you just granted, with all due respect, Your Lordship, you will be sitting on an appeal of your own decision. And my Lord, this court will be making its orders appear inferior to orders of other courts. We urge Your Lordship not to be persuaded at all to grant any orders of status quo. My Lord, fourthly,
Yes.
there is grave injustice and prejudice that is going to be suffered by the people of Meru and the voters of whom I represent by an order of status quo or stay or an umpteenth time applied for conservatory order. My Lord, that will be in breach of Article 10 and Article 1 of our Constitution. My Lord, fifthly, we are alive that the petitioner has a right to appeal against the decision. The superior courts may grant orders of stay if properly seized of that legal mandate. But Your Lord, as far as you're concerned, you've done your work. We kindly ask you not to allow a stay of that decision even for a second. People have never been waiting for this judgment. The court has rendered itself. It's upon all of us as parties to take up our other rights, and the constitutional frameworks and set standards should now take effect. We are established.
Thank you. So give me about 5 minutes to write. Yes.
The amount is not particularly inside. I pray for 5 minutes, Your Lordship.
Now, because we have so many interested parties, if I extend to yourselves, for fairness, I'd have to extend to others. It's a straightforward issue. I think every counsel who walks into a court in this country and beyond has an application for stay in their mind, or how they will attack an application of stay if their side has won. So I'd request that you allow me to give my ruling, and we leave it at that.